Attorney David Coale, thank you so much. With House Speaker Nancy Pelosi sending the article of impeachment against former President Donald Trump to the Senate today, and with the Senate already scheduling a trial for February 8th, I'm wondering, one question that has come up is the Chief Justice of the Supreme Court going to preside over this case? Because this is not a case where you have a sitting president. What do you think of all this?
It's a very interesting question. The text of the Constitution is not clear about the Senate's power to try for impeachment someone who was once president but no longer is president. There is one provision that suggests in Article 2 that defines the power of the president. One provision suggests that impeachment should be limited to the person sitting as president. There's another provision, Article 1, that defines Congress's power that suggests that the impeachment power goes more broadly to include any disqualification of someone from holding federal office. Neither clause is particularly complete or direct, and there's room to argue about how to fit the two together. It's just one of those gray areas we have in our Constitution.
So then does the former president have the option of appealing to a federal court and ultimately the Supreme Court before his trial begins February 8th?
That's certainly something his team should consider. As a practical matter, the federal courts are reluctant to get involved in a case until it's over, so they have the benefit of the entire record. But if there's a serious constitutional issue to be raised about an unusual proceeding, impeachments just don't happen every day, it's certainly something they might be interested in. Although there's a powerful inertia for the courts to just wait and see how it goes, particularly when the text of the Constitution isn't that clear. It's not that perfectly clear the Senate can go ahead, but on the other hand, it's not so clear that someone could come in and demand emergency relief because they have the clear right. The ambiguity of the Constitution cuts both ways on that.
Right, because Article 1, Section 3 says the Senate shall have the sole power to try all impeachments.
Right.
So that gives them the authority. Whether it's right in this case is another story, right?
That's right. And we look to history sometimes to try to guide us. We don't have court cases that deal with this issue. The Senate at least twice has conducted impeachment trials of officials who have left office. There was a senator way back in the late 18th century, and there was a trial of Ulysses Grant's Secretary of War in 1876. Both of those trials began after the office holder had left office, but they both kind of fizzled out. The Senate abandoned the one from the 18th century, and it did not proceed to a judgment of impeachment against Grant's officials. So they have in the past seen themselves as having that power, but that's not really a binding precedent the way a court precedent would be. The Senate is free under the Constitution to reach a different view today and form a different political consensus.
And I mean, while it has been done before where former officials have been tried, it has never been the case of a former president.
That's correct.
Is that strong enough to be, an argument?
It's a data point, I would say. It's certainly relevant that the Senate twice in its history reached a similar conclusion to the one they appear to be going to reach here, but it doesn't involve the president. 100 years plus has passed since the last time it was seriously engaged with an official, even somewhat close to the president. So it's relevant history, but it's not really binding, and the Senate would be within bounds to say it's just a different world today. We have a different situation here. Here's what we're going to do in light of these considerations. I think the Constitution gives them the power and the ability to make that kind of assessment.
So what options does, if in fact the Chief Justice does go and preside, what options does he have?
Well, historically, the Chief Justice, we've had 3 impeachment proceedings involving presidents. Historically, the Chief Justice is sort of a potted plant. The Senate has rules that govern the procedure for handling impeachments. They say, when you talk and how you handle motions, and the Chief Justice is in there. And it's a role kind of like the Vice President has when he or she presides over Senate proceedings. It's ceremonial, ministerial, housekeeping. So that's historically what's been done. That's the way the rules have been written. That said, the language of the Constitution talks about having a trial with the Chief Justice presiding. And that's a very different thing than being a potted plant. Federal judges have enormous power over the proceedings that are in front of them. And at least the very first impeachment that we had of a president, Chief Justice Chase at least considered a more muscular role that he ultimately took on. So while historically the Chief Justice has been, and understandably, very reluctant to be aggressive and assertive in these proceedings, the Constitution's text does potentially give him the latitude to do so, such that if the president early in the proceedings said these should not go forward, he might be able to entertain an early motion to dismiss the proceedings. That would be uncharted territory, but it's not foreclosed by the text of the Constitution.
So if the Chief Justice were to grant that motion, right, by the former president, if he were to bring it up, and he were to just dismiss it, there's really no other place to go, right? There's no appeal, right?
It would be very, it would be a very confusing situation. In theory, the Senate could say, well, we still are the Senate with the exclusive power to try impeachment, and we just don't recognize what the Chief Justice did. If that happened, a court would probably have to resolve that standoff at some point, probably with the Chief Justice recused. Because that is such an awkward situation, that's why the Chief Justice in the past has tried to avoid that kind of problem. It would be a constitutional crisis type of situation, but it's you are correct that if the Chief Justice and the Senate got at loggerheads, the Constitution just doesn't have a way of working that out. It assumes that they're going to get along and have the same general frame of mind about how the proceedings should go forward.
Wow. Okay. So one thing, when I interviewed Senator Cornyn last week, he said there's no precedent for this, and we discussed that a little bit before, because there's no president been in, or former president been in this situation. And his point was the Senate should be very cautious about moving forward, because whatever the Senate decides would set precedent. And he said that's what the Senate does, is follow precedent. So his point then was, if the Senate does go forward with this of a former president no longer in office, what is stopping, in the future for going back and saying, going against, let's say, Democratic former presidents? Is that a legitimate point?
Yes, there's force to that position. I mean, impeachment is a very serious matter. It's only happened 3 times of a president in our nation's history. This will be the 4th coming up. And it takes a lot of time and a lot of resources. And while the Senate's precedents aren't like court precedents, they are very mindful of history. Their rules are built on the lessons they've learned from the past. And it is true that if impeachments become sort of a habit, particularly of past presidents, that would be very disruptive. That said, the Constitution requires a 2/3 majority vote to have a judgment of impeachment. That's never happened for a president. And that may be the ultimate check. If articles of impeachment get passed by the House more and more for whatever reason in years ahead, that 2/3 majority requirement is still a serious check on where that actually goes anywhere. So the senator makes a very valid point. As a practical matter, while the proceedings may be disruptive, the actual act of impeachment is very hard to get to unless there's a really solid consensus that something wrong happened and you're able to reach that 2/3 majority.
Right. I was just going to ask you about that is such a high bar to achieve.
Yes.
That your point is that's really the ultimate bar. And
if you had a situation where you have a series of presidents, God help us if this is the case, but a series of presidents where there is in fact a 2/3 majority every time willing to convict, it sounds like we have a big problem. I just don't think it's likely we'd be in that situation. I think that we've survived 200 plus years and just haven't found ourselves there yet. And it's unlikely that even if we do happen to find ourselves there now, that we'll continue to find ourselves coming up against that. That's a very demanding requirement, and the history of these impeachment proceedings in our country really supports the view that it's not likely to lead to a habit, so to speak.
Right, and because it's so difficult to reach the threshold to convict a president or whoever.
Yes, it's an interesting separation of powers issue. We talk about the 3 branches of government, but here's one where our framers divided power between the different houses of Congress in a way that made it particularly difficult for Congress to get something done. And that served us well. It's good that we have a dialogue about impeachment when serious issues come up. It is not good to have impeachments without a good foundation for them. And that 2/3 majority has prevented the impeachment remedy from becoming something stronger than it was intended to be.
So given that the case, I mean, we have an evenly divided US Senate, 50 Republicans, 50 Democrats, and because it would require 67 senators to convict, that's very unlikely to happen.
Yes, you'd have to have compelling evidence or compelling arguments or something to make up that delta. That's what happened, by the way, with the impeachment of the last really senior official that had left office, the Secretary of War under Ulysses Grant. The Senate conducted the trial and I believe had a majority, a narrow majority, but a majority. It didn't reach 2/3, it died out, and that was that. So a majority is obtainable, 2/3, very difficult.
And given that, you cannot have a former president or any elected official, or excuse me, any president or vice president or any other civil officer of the U.S. They can't be disqualified from running again unless they have also been convicted, right?
Right. So yes, the one thing is clear about the way these clauses fit together, which is that you cannot be removed or disqualified unless there is a judgment of impeachment. And there's only one way to get to a judgment of impeachment. It's with the House having articles and the Senate conducting a trial on that. So where the road goes once the Senate votes is sort of up to the Senate, but that you can't get to disqualification unless you've traveled down that road. Now, that said, there is discussion about another part of the Constitution entirely about disqualification. There's a clause of the 14th Amendment that was originally intended to deal with people that had served in the Confederate Army and the Confederate government. And that's gotten some attention in recent history about whether or not the events of January 6th might trigger that clause. That's separate and apart from impeachment, and it's a whole nother history that relates to that. But it's out there and is sometimes mentioned in the same breath as the impeachment procedure that we're talking about here.
But let's say this, I mean, this may very well be the most likely scenario in which the Senate holds the trial, the Chief Justice presides, it goes through, they don't get a 2/3 majority, therefore the former president is not convicted.
Right.
If that all happens, and you think that's the most likely scenario?
It certainly looks that way now. It looks like the Senate will conduct a trial, and the tea leaves suggest that the vote will be largely along party lines and unlikely to reach the 2/3 level.
So given that, how would, if you know, for future reference, somebody wanted to have the courts, federal court, and ultimately the Supreme Court go back and say, all right, can this happen down the road? Who would make that happen? How would that proceed, do you think?
It would be very hard to do outside of an actual impeachment proceeding. We saw in the litigation about the election results in these battleground states over the last couple of months that who brings the case, who has standing is often more important than what the merits of the case are about. And really in this situation, the only person who has standing is the person at risk of losing the ability to hold office, at the risk of being impeached. And so outside of an impeachment proceeding, it begins to look like what the courts consider an advisory opinion, and they just don't do those. They have enough other business to do already. So I think the question would just go unanswered. It would go into the history books next to Secretary of War under Ulysses Grant and that guy from the 18th century. And another 100 years, we'd look at it as another reference point. It's just not the kind of thing that is built to generate judicial precedent.
Unless former President Trump decides to push that before his February 8th trial.
That's correct. He could try. I doubt the courts would be that interested, but it's a possibility, and there is some reason why they might be interested. Or if he were convicted, like any criminal type proceeding in the court system, he could challenge that in court and say this was not appropriate. The Senate lacked jurisdiction over me, and that would ultimately lead to some kind of opinion. But failing that, it's probably going to wait till the next impeachment, and hopefully that's a really long way down the road.
And if he's not convicted, would he have standing if he wanted to raise that issue?
I doubt it. I think it's over and done with at that point. He's certainly out the money of defending it. He had to deal with the publicity issue, and that would be unfortunate, but that's just the consequence of defending in litigation. It's not the sort of thing that would allow you to bring new litigation and seek that kind of advisory opinion. It's just not the way the courts are set up to operate.
Attorney David Coale, thank you so much for
Thank you,
joining us.
Jack.
Really
Always nice to
appreciate
talk
it.
to you. Take care.
All right, you too.